So when I was settling the Jewel cases, I went back to the school districts I represented and I said, has social media been a problem? And I literally would get that much out of my mouth before they were screaming, yes, this is all we deal with. Can we please do something? Are you telling me there's something that can be done? Where do we sign? This is, a major, major, major problem for our school.
Welcome to the Heart of Law podcast. My name is Mirena Umizaj Dumas, and I'm your host. There are lawyers who build remarkable careers trying cases, and there are lawyers who help shape some of the largest litigations in the country. And then there are those rare few who do both exceptionally well. Today's guest is one of those lawyers. For more than 25 years, Ronald Johnson has built a nationally respected career representing victims of catastrophic negligence, earning the trust of clients, the respect of judges, and the admiration of fellow trial lawyers along the way. Ron secured a $74 million jury verdict, one of the largest personal injury verdicts in Kentucky history, and has negotiated multiple nine-figure mass tort settlements. Federal judges have repeatedly turned to Ron to serve in leadership positions because of his judgment, his courtroom experience, and his steady approach to navigating complex litigation. His peers have recognized him with some of the profession's highest honors, including the Peter Perlman Outstanding Trial Lawyer Award and being named Trial Lawyer of the Year by the Kentucky Trial Court Review. But beyond the accolades, Ron is someone deeply committed to the craft of trial law, to mentoring the next generation, and to the belief that our civil justice system remains one of the most powerful tools for accountability. Today, we're going to talk about the art of trying cases, what it really means to lead a national mass tort, how bellwether trials shape the future of litigation, and why social media addiction cases may become one of the defining legal battles of our generation. Ron, it's such a pleasure to have you here with us. Welcome to the Heart of Law.
Thank you very much for having me. I'm excited to be here.
I've been wanting to do this for a long time. You're a busy man and you're, definitely battling in different fronts and doing incredible work. So I'm super excited to really dig in and see what you've been up to. But before we jump into that, I really want to know who Ron Johnson is. So in the legal circles, people respect you. You have an incredible reputation as a trial lawyer. I'm curious to know, before the verdicts, before the accolades, before the leadership appointments, who was Ron Johnson? What is your journey?
So when I was in law school, very quickly, I'm the son of a lawyer. My father was a partner in one of the largest law firms in Kentucky. And watching the life he had, I quickly decided that while I wanted to be a lawyer, I did not want to be in the big law, big defense firm setting like he was. And I've kind of always had a bit of an anti-authoritarian streak to me. So in law school, I really gravitated toward the criminal defense and the tort classes. I liked that. And my decision was, when I got out of law school, I was going to go to either a small firm or out of my own and do criminal defense work until I was able to start doing some personal injury. And that's what I did. I started off as a criminal defense lawyer. I was going over to the courthouse and picking up cases, everything from traffic tickets to, I handled a murder case and everything in between. But that got you into the courtroom a lot. And then somehow I caught the attention of a famous trial lawyer in Kentucky who's now sadly passed away, named Joe White. Joe called me up out of the blue, asked me to come to his office. I've been practicing about not quite a year, maybe a year. And he basically hired me on the spot. And Joe was famous for, he did all kinds of plaintiff's work, but really medical malpractice was his specialty. And I walked into his office. He handed me a stack of files. They were all medical malpractice cases. I had never done that before. So, I always joke around, like, the normal trajectory for plaintiffs' trial lawyers is you start off doing slip and falls and car wreck cases and you work your way up to the more complex stuff. But I went straight into medical malpractice, which was actually a blessing because in those cases, they're complicated. You have to know the medicine. They're very expert heavy. You have to learn how to deal with experts and prepare experts and find experts. So while it was sort of trial by fire, it was a great foundation to lead me into handling complex litigation. And I worked with Joe for about 5 years until I went up to Northern Kentucky, the Cincinnati area, and joined the firm that I'm with to this day.
Wow. So did you feel like an entrepreneur becoming a lawyer, having your own, carving your own
Definitely,
path?
definitely, because at 2 points in my career, I've been completely out on my own. I mean, at one point, people know this story. I was practicing law out of my car. I didn't have an office. I had a box in my trunk that had all my files in it, and I would park outside of the courthouse and run inside. And they made a movie like years after that I stopped. I only did that for about 8 months, I think, before I got an office. But they made a movie called The Lincoln Lawyer about a lawyer who's in his car. Of course, he had a chauffeur. I did not. I had a I had a Honda Civic, uh, but in those days. But yeah, I was completely flying by the seat of my pants, doing things on my own, very complete entrepreneur. But
Mm-hmm.
I knew that that's what I wanted, was to be in control of my own destiny. Like I said, I watched my father work in a world where he was very constrained and controlled, and how much he sort of chafed against that. And I did not want that life for me. So even though there's a lot of risk and a lot of sleepless nights and anxiety when you're on the plaintiff side, especially when you're practicing out of the trunk of your car,
Mm-hmm.
um, to me it was far better than having sort of the control over me that I never wanted someone else to have. So it worked for me.
Yeah, yeah. Did your dad ever try to advise you against doing what you're doing and have a more steady, job?
No, he actually supported it 1,000%. And in
Nice.
fact, I think I was living the life he had wanted to have. My
Mm,
father wasn't really the type that you would think of in a big law firm.
yeah,
But back when he came out of law school, probably 1971, 70, that's just, you took the job you got, and that's what he got, and so that's what he did. But I think that he always probably wanted to be on my side. So
mm,
he actually was. He passed away about 15 years ago, and he never got to see the real success I ended up having later. But he saw some of my early stuff, and
mm.
he was very proud of me. He was very supportive.
Yeah. Well, I meet a lot of attorneys in my line of work, and so I could tell when somebody just knew they wanted to be a lawyer. There was no question they didn't want to do anything else. Then, you meet lawyers who went to law school and figured out that maybe being a lawyer wasn't exactly what they wanted to do. Did you feel like you were always on the path you were supposed to be in? Like, did you ever doubt that maybe there's something else out there for you, or this was it?
No, once I made the commitment, I was completely committed, but I didn't make it right away.
Yeah.
I thought in college I might go to law school, but then after college, I didn't go straight to law school. I had 2 years that I went out and worked in completely other areas. And it was good for me to do that, because I think if I had gone straight from college into law school, I would have always been wondering. But
Yeah.
by going out and being in the real world for 2 years, and trying to pay your own bills and carve out a life and make a living, by the time I went back to law school, not only was I a little bit older, but I knew for sure what else was out there. And it wasn't, to me, it wasn't as good as being a lawyer. So once I made the commitment to go to law school, I was all in for sure.
Locked in. Yeah.
Yeah.
That's awesome. So, from the outside, right now, at this point in your career, people see all the victories, they see all of the accolades. What parts of the profession are, the parts that demand the most of you personally? Because it's not an easy profession. Like, what do you have to sacrifice to be the kind of lawyer that you are?
Yeah, that's a very good question. I think there's different challenges depending, and I have very close friends who do defense work, and they're amazing attorneys. I think there's different challenges for each side. For the defense firms, they have regular recurring clients. They have to keep those relationships going. On the plaintiff side, it's like every year it's like starting a new business every day. I mean, you don't have recurring clients. You don't have a client. You don't develop a customer that keeps coming back to you. You have someone who's catastrophically injured or killed. You have to take care of them and their family. And if you do so, fantastic, but you never see them again. And then, you got to hope someone else calls you who unfortunately has had that happen. So the uncertainty of being a plaintiff's lawyer, and even after you get to a point where you develop a reputation and you get referrals from other attorneys, I don't think the worry ever completely leaves you. So there's that. Then there's the fact that you're representing people who've had the most horrible thing imaginable happen to them. And so, we're called lawyers or attorneys or counselors. Sometimes there's a lot more counseling on the plaintiff side in terms of being there for your client. This morning before this, I met with a young man whose mother was killed in the UPS plane crash that happened here in Louisville back in November. And I'm representing his mother's estate in that case. And, the meetings with him and his little sister are very difficult because they lost their mom in that crash. So there's that part of it too. And then there's, just the difficulty of winning. We only get paid if we win. Our clients only get compensated if we win. And that's what I care about most. I've had many cases where I've waived my fee to make sure my clients are made whole. But there's a tremendous amount of pressure to deliver for these people because, people think they hear about these huge verdicts and they think but that's not every day in our practice. Most cases settle if you prepare them right and work them up correctly. But you have to be able to obtain enough money for these people so that they don't lose their home, so that their kids still get to go to college. All the things that were going to happen had the father not been killed or the mother not been, rendered quadriplegic. You got to make sure that all their future medical costs can be paid, that they're not going to be totally dependent upon Medicaid or whatever. So there's a lot of pressures on our side. And you see a lot of people on the plaintiff side, I have, just, flame out through, different types of issues. There's a lot, and you have to be able to handle that. And I don't think there is a right way or a wrong way. I know people do it in different ways. But, I've been doing it now for almost 27 years. And I think I'm to the point where, I have a pretty good handle on it. But there are a lot of challenges that go along with being a lawyer, on the plaintiff side, a trial lawyer. And, people make a lot of jokes about lawyers and I can chuckle at those. But, if people knew what we really went through for them, I tell people, they say, what is your job? And I say, people call me up with a really bad problem and I take their problem and I make it my problem. And so if you have a file cabinet full of those, then all those problems are your problems.
Right.
And that can be overwhelming for some people. And that's why the practice of law isn't for everybody. But I think those are the specific challenges that a plaintiff's trial lawyer faces.
Yeah. Have you been able to leave the problems in the office, or do you take the problems with you at home?
I take the problems with me at home. They're in my dreams at night. I wake up in the morning with them. I
Yeah.
Before we started this, I was telling you, I'm really into, my passion is horse racing. And so
Yeah.
I live in Kentucky. And I was, mentioning that in August, I try to take a couple of weeks off and go up to Saratoga to watch the races up there.
Yeah.
But I take my laptop and the races start at 1 and I'm up at 5:30 a.m. working until 1. So, you can't escape it. You just have to develop a healthy way to make it part of your life. And now with phones and iPads and your email, back in the I can say that I predated some of that when I first started practicing. And, we scheduled depositions by sending letters around,
Right.
which was very inefficient, but it did allow for a little bit of escape from your practice. But now we're, You're constantly connected. No, I envy anyone who has the ability to shut the faucet off and really turn it off and be with what they're doing outside of their professional life. But for me, it's kind of always there, and that's not always a bad thing, because if I get up really early in the morning and go for a long walk in my neighborhood, a lot of times that's where I'll think of some great strategy on a case that probably was never going to occur to me sitting at my desk in my office. So having your mind open to your practice all the time, that's sometimes where you get the real epiphanies about
Yeah.
something to do in a case.
Yeah. Do you see yourself leaving the practice of law, before you turn 80?
You know, I will not always do it at the level that I'm doing it now. And I
Yeah.
think that I definitely see a point at which the mass tort multi-district litigation will probably not be in my regular rotation,
Yeah.
because those take so much. I mean, that's like an aircraft carrier versus driving around in a little speedboat. So, there'll be a time when I say I've had enough of that. But in terms of just, being a lawyer, being there to help people, as long as I'm able to do it, my mind and my body, I probably will continue to do it. I think what retirement, for me will look like will be when I am no longer, doing it to run a big firm or business like we have now, but just staying in it to do what I can to help people.
Yeah. I love that. I think, when people say if you love what you do, you never work a day in your life. I mean, I don't know how true that is. There's parts of what I do in running a business that is very empowering, and it's very, it just it makes me feel like I'm in control of my destiny. And I could channel my creativity and help people do a lot of things. But obviously having a family and having kids and trying to create the space to have the quality presence, that does become a challenge. But depending on how you manage that, your own self dialogue and the work you do with yourself, I think there is a way to do it without burning out. But it is an art, right? And I've seen people that could go either way. This profession could be very demanding, and people lose their marriages and their children, and then there's people who through that find that what's most important to them is their personal priorities, and then the profession. You could be better at your profession if your priorities at home are aligned. So it's just it's truly like it's molding your soul and your character in the way, and you have to be aware that that's what's happening. So I find that pretty fascinating. So you mentioned mass torts and this ability to come into mass torts as you also handle single event cases. Why mass torts? Was this a way to hedge your bets, or were you interested in mass torts? How did you end up in mass torts?
So it's interesting. When I started doing mass torts, which was probably 2008, there was only one law firm in Kentucky that I'm pretty sure there's only one law firm in Kentucky that handled multi-district litigation.
Yeah.
And he was a good friend of mine, is a good friend of mine, went to law school together. But
Yeah.
nobody, I mean, now lots of people in Kentucky do this, but now nobody did it.
Mhm.
And what happened was I had no plan to get into it at all. Zero. I was, going to make my career doing single event cases. At that time, like I said, I did a lot of medical malpractice. So a woman came to me. Her son was a high school football player. He had hurt his shoulder in a football game. He had gone to an orthopedic surgeon who had performed surgery on the shoulder. And at first, it seemed like it was a good fix. But about 6, 7 months later, excruciating pain. He goes back to the doctor. They x-ray the shoulder, and all the cartilage in his shoulder joint is gone. It's bone on bone, like an 86-year-old. And the kid was 16. He needed to have a total shoulder replacement, which was a catastrophe at his age, because total shoulder replacements might last 15 or 20 years at that time. And he was 16, which means when he was in his early 30s, he would be out of options. And so she wanted me to sue the orthopedic surgeon. for this, and I got all the records, and I was at that point very experienced doing medical malpractice. And I had an orthopedic surgery expert that I relied on, and we went through it all, and I didn't see anything that, was done incorrectly. Although I did notice that at the end of the surgery, he had inserted something called a pain pump into the joint, which was an external pump through a catheter that delivered local anesthetic into the surgical site for like 2 or 3 days after surgery to help with the pain. And I had never seen that before in shoulder surgery. So I told the woman, I said, there's no medical malpractice case here. I'm really sorry. There's nothing I can do for you. But I kept thinking about the case. And literally 3, 4, 5 months later, I end up seeing in the, either in JAMA, I think it was JAMA or maybe New England Journal, but there was something written by some orthopedic surgeons in Utah who had been using these pain pumps. They were new, and a lot of their patients were coming back with loss of cartilage. And they had theorized that there was something about putting local anesthetic directly into a joint for a long period of time, 2 or 3 days, that could damage cartilage. And I called the lady back and I said, oh, I think I may have figured this out. It's not a medical malpractice case. It's a products liability case. It's a medical device case against this pain pump company. And so I called the doctor and I said, how many patients did you put this in? And he said, oh, all these high school, because he was the high school team doctor for all these different, so, girls that played volleyball and boys that played football. And so I said, you're going to get sued a lot, but I know it's not your fault. It's this thing. Stop using it and send everybody to me. So he did. And I ended up with all of these young people. And that that was never turned into an MDL, but it was a national mass tort. And there was 3 or 4 or 5 law firms around the country that were the head of it. And I was young and I had never done one before. So I called my friend in Louisville, Kentucky, who I knew had, and he said, you don't need me. He said, this is this kind of stuff you've been doing your whole career. You just have a lot of them. So just go in there in that room with all those people and can act like you know what you're doing. And I did. And that was the beginning. We ended up settling all those cases, taking really good care of all of those kids, very good settlements. It totally transformed my career,
Wow.
financially, reputationally. And then I was in with the mass tort world. I knew the players. I knew these big firms around the country that did this every day. I had not known who any of these people were before then. And so from that point, I was very selective, but I was like, I know how to do this now. There's no reason why I should stop. So I always kept my single event practice. But when the right thing came along, or I felt like I was in a position where I could be appointed and I ended up being appointed twice as lead counsel of national MDLs by federal judges. And then multiple times, if I wasn't named lead counsel, I was on the steering committee or the executive committee. So I've been appointed multiple times as leadership in these cases. But it's not what I do all the time. I mean, as you know, there are firms and that's all they do and they're very good at it. And they're my colleagues and my friends, but they wouldn't know what to do with a single,
Right.
construction, injury case like the $74 million verdict we got. They don't do that. And we do both. I do both. So it is a little different. But I think it serves me well to have a foot in both worlds.
Yeah. I find it fascinating because I feel that, to your point, it's 2 different lanes. I remember talking to Mark Lanier, who said he started out trying single event cases, and then once he was in mass tort, there was no going back because it's such a big world and there's so much opportunity. He decided that is where he was going to be. And I keep thinking through all the people that I've met during my career, the 15 years I've been around. And once people jump on the mass tort, wagon, like they just stay, especially if they're being appointed on leadership. I mean, it's a very heavy duty, it's very intense. What have you learned about the mass tort world, like the positives and the negatives? Because there's a lot of politics in mass torts, and
Yeah.
how do you navigate that? It's not for everyone.
Yeah, it isn't. And there's been times when it wasn't for me. And people
Yeah.
say, why do you go back to single event cases? And frankly, it's because sometimes I finish a mass tort or an MDL and I say, I never am doing that again. I'm like, I'm out. I mean, my partners would fall out of their seat laughing right now. How many times they've heard me say that? I'm like, that's it. I can't deal with these people anymore. I can't handle this. I'm just going to go do my own cases.
Right.
Then I'll do that for a year and a half, and then one will come along, a mass tort,
Mhm.
and it's like they pull me back in. And but for me, yeah, it's variety is the spice of life, and I cannot do just one thing. That's what I love about being a plaintiff's lawyer is, if I have a case where there's a traffic control zone in a big highway construction project and it's not done right and somebody gets catastrophically hurt, I get to learn all about that. And then I do a products case involving, an assembly line in a steel manufacturing facility, and I learn all about that.
Mhm.
I love doing something new. And so going in and out of mass torts works for me because it is challenging. The politics are very, and I don't want to sound like I'm bad mouthing it. It should be hard to get in leadership. It should be a challenge. There's been a real movement in the last, like when I first started, the lawyers that ran mass MDLs were white guys. It was me and about 10 other white guys. And that has changed drastically. Now, I'm finishing up, my stint on the committee that was appointed by the federal judge for school districts in the social media case. And the co-lead counsels of that are a extraordinary female lawyer named Lexi Hazam, and a really, really smart South Asian lawyer named Previn Warren. There isn't a white guy in leadership there. And so that's been a positive. There's still, a lot of cronyism and a little bit of gamesmanship that goes on, but it's to be expected. No, you can sit around and try to point at all the flaws in the MDL world and the mass tort world, but what you have to remember is there's no system that's perfect. And it does achieve results that would otherwise be impossible. And that's what pulls me back in a lot is the ability when you have 12, 14 plaintiffs firms coming together, combining their resources to take on huge corporations with unlimited money to defend themselves. And we can make an absolute change, get a product taken off the market, get warnings added to the label, compensate thousands or tens of thousands of people who were hurt. That only happens because all those plaintiffs' law firms came together and agreed to, put in money and do the work. And seeing that, seeing everybody rowing in the same direction. And in social media, it's been, it's kind of renewed my faith. I was really down on mass torts until I got involved in that. And I worked with such amazing people in that case that it really renewed my faith in doing those cases. And it just shows you what can happen. So there's like everything. In
Yeah.
single event cases, there's good and there's bad too.
Right. Of course.
So for me, that's why it makes sense to go back and forth and do both.
Yeah, yeah. What is harder to master? Is it convincing 12 jurors in a courtroom for a single event case, or is it coordinating thousands of cases across the country?
Oh my gosh. It depends on your jury.
Yeah.
Uh, you know, it's true. I have been lead counsel in two MDLs, national MDLs, very big ones. And, you make people mad. You have to make hard decisions. Anytime, like, you're a CEO, Mirena, anytime where you're at the top of the pyramid and you're the decision maker, not all of your decisions are popular. Even you're making the ones that are for the best of the case, but it doesn't make everyone like you. And I have people call and scream at me. And I have been in cases where the lead counsel, I thought, made the good decision, although it was a hard decision. And I know people have called and screamed at them about it. Uh, it is coordinating multi-district litigation is very hard. And that's why the judges, the federal judges who appoint the leadership structure, are very, meticulous about making that decision, because those people have a very hard job.
Yeah.
Plaintiffs lawyers by default, by nature, have independent streaks. These are not joiners, or they would have gone to a big firm. These are lone wolves, and you're trying to get them all in a room and getting them to agree on a common way of attacking a case.
Yeah.
It can be hard, and they're strong personalities. So, one of my really good friends is Chris Seeger. We were co-lead counsel in an MDL together. I learned a lot from him. He's probably the most prolific lead counsel ever in the history of mass torts, and for good reason. He does that very well. He knows how to handle people very well, and I learned a lot from working with him.
Yeah, yeah, he's well known. Yeah, in the mass tort world. So you had a $74 million verdict, which was the Boone County roadway case, and that was one of the largest personal injury verdicts in Kentucky history. When you get a verdict like that, what does it inform you about what's possible, about your abilities?
That is a hard question, because I have lost so many cases that should have been $74 million verdicts. And it's so hard to say. I mean, like you said in an earlier question, what's harder, a 12-person jury? Juries are complicated. And, we have the ability to ask them questions before, and we can, make objections against certain jurors. But it's still, at the end of the day, those are 12 individuals who you only know the tiniest bit about. And what makes them tick, and they can decide things in ways. So, that case where we got the verdict, I knew I tried that case as well as I could try a case. There was no stone left unturned. I knew every detail. I mean, we had so many exhibits in that case, and I knew everyone by the number. I could call them up just by memory. I knew every inch of that roadway. I knew what every speck of gravel in the photographs were. But I've known that in many cases, and I've lost. So it was gratifying to have 12 people say, we see it your way. And the amount of the verdict was important, because it wasn't, I know people talk about, these nuclear verdicts or these lottery verdicts. But this was 3 children who had lost their mother, and the jurors gave them $8 million each, which was $24 million. And I thought and I asked the jurors to give them between 5 and 10, and I wanted the jurors to pick the number that was correct. And they picked 8 for each kid. And then the 50 that made it 74 was for punitive damages, to punish the company, because we proved that they did this. They did it knowingly. They did it on purpose. And then I got them to admit at trial that they had done it on at least 90 to 100 other roadways that were in the community. Wow. And that scared the jury and made them angry. And so, I guarantee you that this company will never make those mistakes again. So the $74 million worked. It compensated those children for their loss. And I guarantee you that company made changes to how they do road construction work, and they'll never do again what they did in this case. So it was gratifying to know that you took care of your clients and that you protected the community, and that when you're a trial lawyer, it's a skill set.
Yeah.
And then you imprint the skills. Everybody can learn the skill set. That's the craft of it. But then there's you, and that's the art of it. Right. And how can you connect with other people? How can you message something? You mentioned Mark Lanier a minute ago. I mean, he's world famous for his ability to connect with a jury. That's the art. And so when everything comes together like that, and the jury recognizes it and rewards you, all I can say is that it's just incredibly gratifying.
Yeah. Well, I've had the honor to work with you and your partner, Jay, in several of your cases. And what stands out for me and my team as we, have collaborated on working with your clients is just the amount of time, the quality connection and relationships you all have with the clients. I mean, they trust you implicitly. There's so much education that goes in. They're not getting to the end of the case and they don't know what to expect. You hold their hand all the way to the end. Um, and I wish I could say that's the norm, and it's not. So it truly makes a difference, which actually makes me um, reflect about, the profession of law and how a lot of attorneys in this profession, they want to become great advocates. They want to run a successful business, but it's challenging because they're trying to pursue excellence um, while they're trying to compete for cases. Case acquisition is hard. Um, and there's other challenges in the personal injury world today, tort reform, all the things that go with making the profession more difficult. Um, so I feel like sometimes they lose sight of, where to focus and how to focus and what kind of business model to create. And is it quality versus quantity? Is it quantity versus quality? And so what advice do you have for somebody that's trying to figure out their business model that truly wants to help their clients, but they have been distracted by all of the challenges of the profession?
Right. And you really nailed it there. That is the most difficult part of being a plaintiff's trial lawyer. And what I think the one conflict that people find themselves in that creates problems for them doing their very best for a client is money.
Mhm.
Because let's say I talk to young lawyers who want to be trial lawyers or even old lawyers who want to switch over to being a plaintiff's lawyer. And I always tell them some variation of this, which is, you know, you can never put your own monetary interest ahead of your clients. And if you don't have the financial resources to make sure that never happens, then it's going to happen. And what are you going to do in that moment? And I look at most instances where I've seen a plaintiff's lawyer make the wrong decision for a client
Yeah.
is where they needed the money more than the client.
Yeah.
And in this day and age where we have national plaintiffs law firms that spend hundreds of millions of dollars on advertising, it's really hard for the small plaintiff's lawyer who's doing car wreck cases to get enough of them coming in the door to cash flow in a way where she's never in conflict with their clients over money.
Yeah.
So, what I tell people is if you want to do this, it's really hard today, if not impossible, to just go out and hang a shingle and say, I'm going to become a plaintiff's lawyer, unless you have, a bank, $5 million in the bank. The better thing to do is, call up a lawyer who's been doing it for a long time in your community, who is very good at it, and say, I just got a call on this products liability case. I had the client come in, I got the medical records, I got the OSHA report, I looked at everything. It looks to me like a legit case, but I have the self-awareness to know that this case is going to cost a lot of money, and it's worth a lot of money because the father of this family of 6 is dead, and they have, they're in dire financial straits, and the insurance company may throw $1 million at me right out of the gate, and I'll look at that and think, oh, I get 40% of that. That's 400,000. I've never made that much in my life. I'll take it. But the family, $1 million isn't going to get the family anything. So I know that I can't do this case alone. Can I split it? I'll associate with you. We'll split it, and I can come to every deposition and learn, and I'll see how you find your experts and how you work your experts up and how you take depositions of the other side to prove the case. And do that until you've done enough of those that then you have the war chest to finance the cases doing them on your own, or that you have enough of a regular pipeline of cases to do them on your own. Because having that, you just have to be, it can never be about the money for you. It can never be about the financial impact on you or your firm. I've just seen over and over again where lawyers have made terrible decisions because they can't make their payroll. They can't pay their paralegals and the receptionist, and so they settle a case. They convince their clients to settle a case for less than it's worth so they can do that. And that's just, you can't do that. You can never do that. And so I would say that until you're up and rolling and to a point where you feel very good about your ability to get cases in regularly, then work with another lawyer who's experienced. You'll learn, you will have no financial worries, and you can do the case the right way, and not have any issues of having a conflict with your own client. I think that issue is the most problematic, and it's the one that young lawyers or new plaintiffs lawyers don't think about enough.
Yeah, it's a great point. Really, really great point. Um, I know that we are limited in time because I could talk to you for hours about so many topics, but I do want to jump into the social media litigation, social media addiction litigation. You are involved in the social media addiction litigation in a new and emerging legal battle against Meta. You are at the forefront of it. So tell me how you got involved and why.
So I got involved because I had already represented, so my clients in the case, and it's against Meta, YouTube, TikTok, and Snap for Snapchat.
Okay.
I got involved because I had school districts as clients already. And in social media, all of my clients are school districts. The school districts have filed these lawsuits against the social media companies because the addiction that social media has caused amongst kids is creating problems in schools, not surprising, which cost the school tons of money, and diverted resources and time dealing with that instead of teaching. So I had previously represented a lot of school districts in the Juul MDL, which is the vaping device, because they targeted kids there. The kids got addicted. They're vaping at school. The schools were suspending and expelling and having to put monitors in the hallways. And so I had all these school districts. And then a friend of mine who represents school districts told me that they were going to be filing against the social media companies for addicting kids because their schools had been complaining about how much time and money they were spending on the problem.
Yeah.
So when I was settling the Juul cases, I went back to the school districts I represented and I said, has social media been a problem? And I literally would get that much out of my mouth before they were screaming, yes, this is all we deal with. Can we please do something? Are you telling me there's something that can be done? Where do we sign? This is, a major, major, major problem for our school. And so I signed up all of those districts from Juul plus more, and we filed them in the case, which was an MDL. And my partner, Sarah Emery, and I were both appointed by the judge as two of the 5 lawyers that she appointed to run the school district cases against social media. And so that is how we got into it. The theory of the case, the causes of action are 2. It's public nuisance, and basically a negligence sort of product liability theory against them. And these are things we've used before. Tobacco litigation was a similar thing. The opioid litigation was a public nuisance concept. The Juul litigation was public nuisance. So this is a new tool in the toolbox for mass tort lawyers to go after corporations that are harming society in a general sense. But in this case, there was also definitely a products liability claim as well.
What is the overall objective of this litigation? What do you hope to accomplish?
That's a good question, because I think some people are worried that we say there shouldn't be any social media or that we're trying to put it out of business, which is absolutely not the case. There's a value to social media, and our schools will most of the schools I represent have a Facebook page. It's a way for them to get information out to the parents in the community.
Yeah.
What we're trying to do is get some guardrails up, just some common sense things like age verification and the ability of the parents to control the account. Very simple things. And to the, I think because of the litigation, you're now seeing commercials on TV where TikTok and others are saying, we've put this in and we've added this new thing, for age verification. So I think it's starting to work, that what we've done is having an impact on them. But that's what we're trying to do. And then we want to get compensation, of course, for the schools because it's cost them a lot of money to deal with this. I mean, schools used to have one guidance counselor. They were talking to kids about, normal kid problems. Now they have six in a school because there are all these problems that are associated with the addiction to social media.
Yeah.
Classroom time is diverted. It's all sorts of IT issues, filters and blocking that they have to add to the Wi-Fi. So there's a lot of things that schools have had to spend money on. We want to get them reimbursed and compensated for that because we don't believe that the taxpayers should pay for that, which is who pays for public schools.
Yeah.
And we want guardrails put up just so that social media is safe.
Yeah. So, I mean, it's an addiction, right? And the ones addicted are the children. And I have three of them, two of which I could say, even with all the guardrails I try to put up as a parent, are addicted to social media, YouTube. Um, what is the solution you think for the kids, for the families? Or is that something that this litigation can't necessarily address?
It's interesting. When we did the Jewel case, the real shock of it was we had succeeded in getting kids to not think smoking was cool. When I was a kid, everybody smoked cigarettes. My stepdaughters never once wanted to smoke a cigarette. It was gross and disgusting, and none of their friends did it. So it took a while, but we solved and cigarettes were marketed to kids. They were
Yeah.
because the earlier you get addicted, the better, and the cigarette companies called it customers for life. So I think that the social media addiction will be similar. We're not going to be able to just draw a line and it's going to be one day there and the next day not. We have a generation who's been, exposed to these algorithms and the other addictive propensities of the platforms for their whole life, and it's not like it's going to turn off immediately. But I do think that we can achieve what we did with tobacco, where maybe 2 or 3 generations from now, nobody will be addicted to social media. It'll just be like anything else. If I'm on my, I don't have, I'm off, I don't have any social media. So if you see me on my phone, I'm looking at my email, or I'm looking at scores on ESPN, or maybe I'm doing the New York Times, Wordle. But nobody's addicted to Wordle. So I think we can get to a point where social media is like that, and it's not an addictive thing. But it'll take a while, and it's gonna, like I said, it's gonna take putting up some of these guardrails to make it safe.
Is there anything like just very briefly in terms of the science? Did you guys dive into the science? Like, for example, with I don't know if I can pronounce this correctly. Is it breathitt?
Yes.
Okay. Obviously, you had a settlement with Breathitt, which is the county school in Kentucky, and that became a bellwether case. Is that correct? Which you guys settled right before trial. Was there any science that you were able to use or evidence? I know that there is some confidential terms, but without going into details, what can you share that made this a no-brainer, meaning they had to settle this case?
Well, I don't think that it was ever a no-brainer, and I think that the defendants would definitely say liability was contested. But
Yeah.
that said, and this is not confidential; it's publicly available. But in all of the bellwether cases, not unique to Breathitt, but there was extensive briefing on. They filed motions for summary judgment, of course,
Yeah.
and we disclosed the opinions of our experts, and many of whom were physicians and social scientists who had studied this, and there was published literature on it, and there is ever more each day.
Yeah.
I think that in 20 years, with hindsight, this will be a completely known and established thing. Um, but we definitely were at the beginning of the emergence of the publication of peer-reviewed literature talking about the link between social media, children, and addiction. But it was there. It was there, and it was certainly there enough for the judge to look at it and say, yes, this is legitimate. I'm denying the motion for summary judgment. I'm denying Daubert motions to exclude these witnesses, and this is the testimony that's going to come in at trial for all the cases. So the science has been there. It was emerging when we started this case, but it's definitely there.
Yeah. So what's next? Are you like just in terms of what happens to other schools around the country? Is this something that your team, the leadership, will continue to systematically pursue? Like for somebody that doesn't understand what mass torts is, can you briefly explain sort of the overall strategy of this MDL?
So the court has set a number of bellwether trials.
Okay.
And so the next one up, it would be in February. It'll be Tucson School District in Arizona.
Okay.
And after that, she'll set two more. And then after that, two more. And so we will continue to prepare those just like we did Breathitt, and get ready for trial. And our hope certainly is that at some point there is a resolution that helps all schools. But to the extent we have to do school by school, that's what we'll do. But that's sort of the normal thing for an MDL. Nothing unique about this MDL in that regard.
Okay. I have a question which kind of makes me think, this litigation makes me think of opioid litigation. Because similarly, in the MDL, the counties were represented, not necessarily the people.
Yeah.
And I am working with a firm that's been trying to bring the NAS cases, the addicted baby cases, and is making a lot of progress. Is there a possibility that, to the extent that the science continues to prove how much of the brain is altered from social media addiction, could there be those cases as a separate MDL in the future?
You mean for the individuals who are harmed by the
That's right. The
so
children.
yeah, so in this case, unlike opioids, you're right, there were not individual cases in opioids, but in this case there are.
There are.
So there are three categories of plaintiffs between the MDL, which is in federal court in Oakland, and the California Coordinated State Court proceeding, which is in LA. And between those two courts, there are states' claims brought by the attorneys general. There are school districts' claims brought by attorneys like me. And there are individual claims brought by firms that are just, representing teenagers and young people who have been harmed by this. And
Yeah.
in fact, the very first bellwether case that was tried was in the state court proceeding, and it was by Mark Lanier. And it was for an individual young woman who alleged that going back to her preteen years, she was addicted to social media and that it caused significant mental health harms to her. And the jury awarded $6 million to her in that case. So, yes, unlike opioids, here the individuals are being represented as well.
Okay. Okay. I wasn't aware. I haven't followed. I think a lot of the information that's on social media is on social media. So it depends on who's posting what, but it's good to know. I think that's very informative. Um, how are we on time, Ron?
We can go for a bit more.
Okay. So I want to switch to just talking about the future of the plaintiff world. There's so much tort reform going on around the country, and there is technology entering the legal space. There's capital entering the legal space. What are your views about the next 5 to 10 years of the plaintiff, trial lawyer, who survives and who's consolidated and wiped out? Is that something that lawyers talk about? What are your thoughts?
Yeah, I've given this quite a bit of thought. I think with the idea of private equity capital coming into the plaintiff side, hedge funds, etc., I think that's an issue, but I think it really applies to those who are seeking to turn plaintiff's cases into a commodity.
Yeah.
And if that's the way you practice, and it's not the way I practice, then you should be concerned, or you need to be getting in front of that wave because it's coming. And if you think that the practice of law and the representation of individuals can be a commodity or should be a commodity,
Yeah.
then private equity is coming for you because they are the money that you can't match. But I think for those who still believe in doing the cases as a personal relationship with another human being, the counseling part, you can't commoditize that.
Yeah.
And so private equity cannot touch that. With the AI, I have friends in the defense bar who are very concerned about it because their financial model is the billable hour. I know that some are probably going to have to move to a flat fee because it was the previous model was based upon a partner having a client. The client hires the partner has multiple associates below him or her, and they all work on the case and they all bill by the hour, and the large amount of billable hours times the hourly rate translates into a big fee for the firm.
Yeah.
Well, with AI, people are not going to look at some of these bills and say, I'm not paying for all those hours you had an associate researching this, because the firm down the street does the same thing with AI, and I don't get any of those bills. And so I think in the defense bar, there's going to be a sea change because of the presence of AI. And I think that we're going to see firms that have been around for 100 years, 200 years, that are going to go away, because only those who are early adopters are going to stay in the game. I think AI is less of a problem for plaintiffs' lawyers because we aren't a billable hour model. We are a contingency fee based on a result model. So, and sometimes that is to our benefit, and sometimes that is to our detriment. Sometimes you have so much time in a case, and it settles because of policy limits or other issues for far less than you would ever be able to justify that time for.
Yeah.
So I don't see AI as a tool, and we're using it in my firm, and lots of other plaintiffs' firms are using it, but I don't see it materially affecting the way we do things. I think the capital coming in, the ability of non-lawyers to become partners in a law firm like we see in Arizona, I think those are things that are going to affect it. But I think I feel good in my space. I know how lucky I am with our firm and what we do, and my colleagues and friends are in similar firms. But I think for a young person coming into the business and wanting to be a plaintiff's lawyer, coming into the profession, I should say, and wanting to be a plaintiff's lawyer, it's a much harder time than when I came in, for sure.
So to somebody that is in their 30s and they're trying to figure this out, whether they're in Kentucky or in California or in Florida, what are some simple, bullet point type advice that you could give? Like, what are some steps that they should be taking to at least begin to prepare for whether it is growing, scaling, or maybe not, maybe just partnering, like you said, with somebody that has been doing it for some time? Like, what are some very easy steps for somebody that wants to survive in this business?
I think if you want to survive, you have to, and you want to stay independent, um, you have to think outside the box. That's been my whole career. I joke with my partner Jay, who Jay does a lot of auto and trucking cases, and we joke around that I wouldn't know how to do one of those because I know I mean I do, but I don't get car I never got car wreck cases as a young lawyer, and I was envious of those who did because those aren't as difficult and it's a good way to make money and cash flow, and I wasn't getting those, so I had to figure out. I had to do cases that other people didn't want to do or didn't think about doing. I think that's always the future. I mean, you look at some of these big national plaintiffs firms that advertise all the time. What are they looking for? They're looking for car wreck cases. That's what they advertise for, semi-truck cases.
Yeah.
Okay, well then do something else. People need help and are injured or killed by lots of things other than car wrecks.
Yeah.
So, one of the areas that I do is road construction defects and traffic control zone defects and work zones on roads. I don't know many other lawyers in Kentucky who are doing that. Those cases are out there. There's lots of them.
Yeah.
And I get calls on those right and left. So I would say that's your number one.
Innovation. Yeah.
You can't, because you can't compete with these big national juggernauts. So innovate, exactly, and then make your own space.
Yeah.
And that, as long as you're willing to always do that, if you want a comfortable chair and just sit in it, then you're probably not going to make it. But if you're willing to take that's what being a plaintiff's lawyer is. It's risk taking chances. So do it and think outside the box. That's what I would tell someone in their 30s.
Yeah. And try cases. Not a lot of people do.
Yeah, you have to try cases, but it is so hard to try cases anymore because the entire system is geared towards settlement. The judges push you to settle. The insurance companies will, once they offer you an amount of money that, I tell my client, I said, this is probably better than what I think we could do at trial 9 times out of 10. How do you turn that down?
Yeah.
But yeah, when you have an opportunity to try a case, you must take it. Yes, you have to try cases. At one point in my career, back when I was doing medical malpractice, I think I lost like 7 in a row. But I was doing them, and I was getting a reputation as someone who wasn't scared to go to court. And so even though I was losing, and I wasn't losing because I was bad, I was losing because the cases were so hard.
Right.
But I was still willing to do it. And then they started settling. Then they started paying me and settling with me because they're like, this guy will go to trial. He doesn't care. He's crazy. In this case, he can't win the case, and he still doesn't.
Right.
So yeah, you got to try cases.
You got to earn the reputation,
Oh,
right?
yeah.
That is, you could settle the majority of your cases, but they know that you're not afraid to go to trial. And unfortunately, a lot of lawyers don't try enough cases to be feared to settle good cases for good amounts of money. So yeah, I couldn't agree more. Tell me about your passion. Tell me about horse racing. Tell me why you love that. What does that represent? And does it provide some sort of humility in that sport because you can't control anything? It's just pure fun.
So you are one of the few people who are not from Kentucky who understand it very well, because that is exactly right. So I grew up in Louisville, Kentucky, born and raised. My father would take me to the racetrack. I would watch him bet. He taught me how to read the racing form and place bets and go into the paddock and look at the horses. And then, I just fell in love with it. Not the gambling is the least interesting part to me. I can go out to the track and not bet $1 and have as much fun betting and winning big. And then, about 10 years ago, I got to the point where I could afford to start buying some horses and racing them. And now I have my own racing stable, and I've had the opportunity to breed horses. These are all thoroughbreds, of course.
Yeah.
And it's just, it's the human connection to an animal. It's the relationship. I mean, people who I love dogs, but horses are even, like, humans would not be where they are in the world today if we didn't have horses. Like, they changed us. What they enabled us to travel over distances and carry things. And it's just it's a romantic sport. And yeah, you don't have any control over it. And there's a ton of disappointment. There's 99 disappointments for one moment of triumph. And that moment of triumph is
Makes up for it all.
Oh my gosh. I had a filly, my first filly that won a stakes race. My wife was with me, and I don't even really remember what was happening with the horse coming down the stretch, because she overtook the other horses, and it was just like something out of a movie. And I know I lost my mind. And my wife afterwards was like, you should have seen yourself. You went and I've never seen you like that, because I'm usually a pretty reserved guy.
Yeah.
But yeah, and you meet great people. In horse racing, there's a term, the connections, and the connections refer to the owner, the trainer, and the jockey. But that's what, and it's a great word because that's what the whole sport is about. It's about making connections.
Yeah.
And so I have all these great friends I've made now, partners that I've, gotten into on horses with, and the trainers are my good friends, and some of the jockeys and the farms where I've kept my brood mares. So, for those of you, anybody who listens to this, if you haven't been
Yeah.
to Kentucky, please come. Please, go to Lexington, go to Keeneland. Even though
Yeah.
you've heard of Churchill Downs, go to Keeneland. They race in October and April. It'll change your life.
Well, I've never been, so it's on my
Well, you're
bucket list.
you're invited. We're,
I would love to. I would love
we're
to.
taking we're taking you in October.
That would be a great birthday gift. Um, I have friends who actually use horses for healing, um,
Yes.
for people with all kinds of diseases and illnesses. And at first I was like, what is this about? And I got the chance to speak to one of these good friends of mine I met through meditation work. And she said it is the most powerful thing. You cannot describe that in words, but when you're in the presence of these horses and you're sitting there with them, like there's this transformation that happens. So to your point, the connection and the exchange of energy between this beautiful, noble animal and us and the history we've had. I was captivated by that discussion.
It's a real thing. And I tell you just real quickly on that point, one of the things I'm very active in is what's called the Thoroughbred Aftercare Association, because these horses, they're athletes, and they have their career ends and they still have a lot of life ahead of them. And
Yeah.
and some can go to the farm to become, sires or brood mares, but not all get that lucky. And we need to find other jobs for them so they can have a meaningful life, because they've been bred and domesticated to interact with humans, and they like it. They have jobs. They love having a job. And so, there's many things that a thoroughbred can do after the track. And one of them is that type of care that you're talking about. And so this organization that I help raise money for, that's what they do. And I love it, because people have a response in the presence of horses that will shock you,
Mm,
because they are such majestic animals.
hmm. Wow. I love it. I love how you light up talking about it too. You could tell it's a passion. Well, it's been so enlightening talking to you, Ron. Thank you so much. And just to get to know you, to have this quality hour and 15-minute conversation. Thank you so much for everything you've shared. And to anyone who hears this and has questions, I know, Ron, you're very approachable, and I know that there is a whole generation coming after you that would find you to be a great mentor. So I invite our audience to reach out to Ron and have meaningful conversations. He's a great human being. Thank you so much.
Mirena, thank you. I know everything that you said. I feel the same toward you, and how you conduct yourself, and the way your company takes care of our clients. You're a game changer in your industry, and Jay and I are so thankful that we have you involved with us on our cases. So thank you.
Thank you so much. Means a lot to me. Appreciate you. Have a great
Absolutely.
day.
You too. Bye bye.